I'm Nathan Freeberg of Cave and Freeberg LLP, a worldwide court-martial defense firm. So, you've just been handed a court-martial charge sheet. What happens next? Well, the very first step is what's called an Article 32 hearing. This is a hearing that both determines probable cause and makes a recommendation as to whether your case should go to trial. Sometimes it is possible with the right counsel and the right arguments that you can actually end the case here at the Article 32 hearing. But ultimately, what the Article 32 officer writes in his or her report is only a recommendation, and the commander of the Office of Special Trial Counsel can ignore it. So let's say that they do decide to send the case to trial. The next step is what's called the referral charges, where they'll just hand you the charge sheet all over again, just like they just did. After that, you'll actually get a judge assigned, and the very first time you'll appear in court is what will be called arraignment. You'll put on the dress uniform, most likely. You'll appear in front of the judge, and you'll go through about a 10-minute legal formality, but it does have some legal consequences. After that, your defense attorneys are entitled to file discovery demands and try and get all of the evidence against you, and you'll be able to see that too. They'll also be able to request witnesses on your behalf, experts, and ultimately file motions as a way to shape the trial. Sometimes motions can be used to end the trial if, for example, certain evidence is suppressed. Other times it's to keep out certain types of government evidence that's unduly prejudicial against you. And all these steps are gone through, and then finally you come to the court-martial itself. The very first step there is what's called voir dire, which is just Latin essentially for choosing the panel members, the jury. And what happens there is your attorneys, such as us, will be able to question them for bias. Once the panel is seated, the prosecutor gives an opening statement, your defense counsel gives an opening statement. The prosecution calls all of their witnesses first, subject to cross-examination by your defense. Then the defense goes, and the witnesses on your behalf are called. Then the prosecution gets a rebuttal case, if they have any. Then the prosecution goes up and gives a closing argument. Then your defense counsel gives a closing argument. Then the prosecution gives a rebuttal to your defense's closing because they have the burden of proof. And then the panel goes back and deliberates. And at some point they come back with a verdict. And hopefully what you hear at this point are the two most beautiful words in the English language: not guilty. If you have any more questions about the court-martial process, please give us a call at 202-931-8509 or use the contact form on our website, 202-931-8509.